The biggest corrupting force in state politics, Sacramento legislature, the governor, Los Angeles, the local city council, they're corrupted by, more than anything else, public union money, without question. And if you want to work, you have to join the union. And some of your money goes to political advocacy, contributions to politicians, legal bribes, contributions to political action committees.
Yeah, remember when Gray Davis asked the California Teachers Association for $1 million, famously years ago, before he was thrown out of office?
Right. And that's why we have billions and billions of dollars of debt for pensions that we'll never be able to pay. And it crowds out spending for anything else that's useful, like roads. Well, the Supreme Court is going to decide whether that's a violation of some workers' rights. Why should you, as a union worker, have to pay these fees if they're spending the money on a political agenda you disagree with? Seems to violate your First Amendment rights to spend money on political agendas you do agree with. And we're going to talk now with Mark Mix, president of the National Right to Work Legal Defense Foundation.
Which is defined on their own website as a nonprofit charitable organization. The mission is to eliminate coercive union power and compulsory unionism abuses.
They are representing Mark Janus. Mark Janus is an Illinois child support specialist, and he is named in the lawsuit that the Supreme Court is considering now. Mark Mix, welcome to the John and Ken Show. How are you?
I am doing fine, and it's great to be on this show. What a privilege. I understand this is the most listened to local talk show in the country. This is big news.
That would be true, yes. Thank you very much. That's a way to ingratiate yourself with the hosts. That's wonderful.
And, of course, we have followed public employee unions for many years here on the John and Ken Show, Mark, and particularly the powerful ones that rule Sacramento. So we have a big interest in this story.
Now,
indeed, yeah.
I
used to work in Sacramento, so I know of what you speak.
Yeah. So explain, let's give a quick overview for people who aren't in public unions. When you join a public union, you obviously have to pay union dues. But I thought there was a partial exception where you only had to pay a little bit of union dues if you didn't want to actually be a member. Can you just explain the difference?
Yeah, that's right. And that comes from a case in 1977, a case called Abood, which is in play in this most recent Supreme Court argument that occurred on Monday of this week. Basically what happens, Ken and John, is that as a public employee in the state of California and 21 other states, you can be compelled as a condition of working for your government to pay a fee to a private organization, i.e. a labor union. The question in front of the court at Janus last Monday, and the question that hopefully they'll rule in our favor, in favor of Mark Janus, is everything that government unions do political? And we say, yes, it is. We said that back in 1977. We said it in 1986. We said it in 1991. We said it in 2007. We said it in 2012, 2014, and we said it on Monday. Those are all Supreme Court cases that have been litigated about government union power over citizens and taxpayers and government employees. We're saying that everything they do is political, and therefore it's protected First Amendment speech, and it cannot be compelled. That's the question in front of the court.
Well, of course, you're right. Everything is political because it's politicians that decide what the public employee unions get for pay, benefits, everything. That's why we said on the show they should not be allowed to unionize, because by its nature, it's completely insular and dangerous.
Yeah, indeed. And you would be in agreement with Franklin Roosevelt, somebody you probably don't agree with very often, but you would be in agreement with him when asked that same question back in 1937, should we unionize the government? He said it's unthinkable we would unionize the government. In fact, the AFL, Executive Council in 1959, said the same thing. But unfortunately for taxpayers and folks in California and in these 21 other states, the money in the government sector is so compelling that union officials went there as kind of the final frontier, and that's really where their power is. And in California, you have labor union officials that kind of joke about the fact that they get to elect their own bosses, and that's exactly what you're talking about.
That's exactly what's going on, because the money that the unions raise is tremendous, and they spend enormous amounts of money on political campaigns and political action committees and get virtually everything they want. I mean, there's no other way you could explain the billions and billions of dollars in unsustainable pensions that we owe.
Yeah, indeed. And that power that they wield gives them control over the political process, which is the lobbying process. So we believe, and Mark Janus believes, and cases out of California, the cases that I mentioned, we argued a case in 2012 on behalf of 10 California state employees, going back, I think you mentioned it, when Gray Davis, when they had all these ballot initiatives, actually when Governor Schwarzenegger was the governor out there, they had 5 ballot initiatives, and the union bosses told the controller of the state of California to deduct a, quote, political fightback fund from every single public employee in California. Well, we litigated that case on behalf of California workers. That ended up in the U.S. Supreme Court, and we got the court to agree that workers had to opt into that type of thing as opposed to opt out, which was a really big step forward. The next case was a case we won in 2014 called Pam Harris versus Quinn, who was then the governor of Illinois, that basically made the argument that said everything the union's doing is political. And the argument we made on Monday on behalf of Mark Janus is that everything they're doing is political, therefore it's First Amendment speech. It's got to be protected. It can't be compelled. We think we may win this case, and that would wipe out the compulsory fees for every public employee in California.
Now, that would not
Yeah.
eliminate union dues entirely.
No, well, no, if you want to pay union dues, you can, but you can't be compelled. You would pay zero if you decided not to join the union and didn't have to pay the fee.
Well, then how does that, but they are part of the collective bargaining process. How does that work then?
Well, that's what they say. That's their argument. Well, we do all these great beneficial things. What we would say is that bargaining process is political because what they're doing is they're trying to convince the legislature how to allocate taxpayer money, whether it be on teacher tenure or merit pay or, all these things they negotiate over, hours of the classroom are open, days off, all those things have a monetary value and they become part of the allocation of resources. So basically what we're saying is you can't compel that because everything you're doing, your lobbying, your bargaining, all of that with government is First Amendment protected speech.
Because the way it works is, I guess, and correct me if I'm wrong, because I've always been a little confused on this, you don't have to join the union, but you have to pay the dues anyway.
That's correct, right.
So you could be legally separate from the union and not belong to it, but you pay the same price, right?
Well, you pay. They say you don't pay the same price, but they get to figure out how much you pay. They say, well, this is how much you owe, and you have to live with that.
Right.
But if you're like a state worker in California and you're part of one of these unions, whatever you want to pick as an example, and they're negotiating a contract, I thought everybody gets the raise. But if you decide not to be in the union, let's say you win this case, what would happen to that employee in terms of what he gets in terms of raises in the next deal?
Well, the assumption there is that somehow government can't function without a union bargaining. That's just not true. In my state, in Virginia, we have a statutory prohibition against recognition of unions and bargaining for all government employees. But yet, my brother, who's a state employee, gets paid. He gets vacation days. He's got a nice pension. And Virginia is in pretty decent financial shape compared to California. We also have right-to-work laws in Virginia. So the idea that you have to have bargaining is just not true.
A right to work means you have a right to work without joining a union.
Without joining or paying dues to a union. That's absolutely right. So that's what the unions argue. They say, well, we do all these things that are beneficial to all these employees. Well, what's the definition of benefit? We've had a case where we had one employee who got a promotion, and they had another employee who objected to the promotion because they had been on the job for 1 day longer than the guy that got the promotion. And so the union had to represent one or the other of them in this, quote, bargaining process. And so we just believe that the communication between elected officials and their employees is something that can happen without a third party present. I mean, obviously, union officials want us to believe there's no way these relationships can occur without their involvement. That's just not true. It's this monopoly implementation between taxpayers and government officials that has caused this problem. We say they will be able to have their voice heard just like you and I do. You have obviously a very loud voice in California. When you ask people to do something to contact their legislator, they do. And you create great power in your marketplace with this particular show. Unions can do the same thing. Compelling government officials to listen to them is the question where this all goes off the rails because they are in a unique position in between taxpayers and government and elected officials to basically affect public policy. And you can't make the argument in the private sector, but in the public sector, they don't belong there. And so the bargaining process doesn't belong there. And therefore, it's all political when they're bargaining, and therefore it should be protected.
Can you hang on, Mark, for a couple more questions?
Sure, absolutely.
Because I want to see where this goes. And
right.
If you
guys win, what happens to these public unions here in California?
All right, let's see. We're talking to Mark Mix, who's president of the National Right to Work Legal Defense Foundation, and He represents a public employee in the state of Illinois by the name of Mark Janus. This is a big case in front of the U.S. Supreme Court about those public employee union dues.
John and Ken, KFI.
KFI AM 640. More stimulating talk.
John and Ken Show. John Kobylt and Ken Chiampou, KFI AM 640. There's a case before the Supreme Court that could dramatically change the power that public employee unions have.
You imagine, especially here in California, where they run Sacramento. Everyone says that. Everyone knows that, especially like the California Teachers Association.
Because if you work for a public union in California, you have to pay them a fee. Even if you don't want to belong to the union, you still have to pay it. And the money goes in part to political donations to candidates and political action committees.
Yeah, legal bribes.
And it's not your political belief system. Why do you have to spend money on that? It's really against your First Amendment rights.
Well, the case is of Mark Janus, who was a government worker in Illinois. That's the case before the U.S. Supreme Court, but it's all about what John just talked about, these fees.
Mark Mix is with us. He's president of the National Right to Work Legal Defense Foundation, and they're representing Mark Janus. Now, Mark Mix, so if you win, and I'm a public union employee here in California, do I have to pay anything?
You don't. You can. It's be completely voluntary. If you want to pay your union dues, you can do it. If you want to give them your entire paycheck, you can do it. If you want to support their political campaigns, you can do it. But if you don't, you won't have to, because the fundamental issue here is, can the public sector union officials in California force you to pay them to speak, quote unquote, I'm using my finger quotes here, to speak on your behalf to the legislature? And so this raises that First Amendment question. It's been a question that's been pregnant since the power of government unions increased in the 1970s through the 80s and 90s, and now it manifests itself in situations like California, where everyone knows that the government unions are the most powerful political force in your state, and they are the most powerful political force because they can compel everyone to pay them a fee as a condition of work.
What percentage of their annual income will be lost if this happens and you win?
Well, that's a really great question. And obviously, if they're going to continue to provide great service to their members and to those people that they want to represent, then they probably won't have any problem at all. Unfortunately, they've been so lazy about their services because they can compel these fees that I suspect there's going to be a lot of folks that will say, you know what, we don't want to pay anymore. We've got a couple of examples from Wisconsin back in 2011. Governor Scott Walker radically reformed the bargaining process. They didn't eliminate bargaining. People will tell you they eliminated bargaining up there. They did not. They just limited the scope of bargaining, and then they allowed for right to work for government employees, meaning they were no longer compelled to pay fees to keep their jobs. And they also did a few other reforms that made unions prove themselves again and again and again. Like in California, if you're a teacher, you never voted on being in the union. That union agreement existed years before you ever came into the classroom, and you're just part of it because that's the way it goes. So what we expect and what we saw in Wisconsin was a fairly significant drop in revenue in a couple of different units. Some unions were doing good work and they kept their membership. Other unions were lazy. They lost a lot of membership, but now their business model has changed.
But did it change their political influence?
Absolutely. I mean, you look at it from the standpoint of we passed a right to work law in Wisconsin, we passed a right to work law in Michigan, we passed a right to work law in Indiana, we passed a right to work law in West Virginia over the last 5 years, and politically it's changed everything. You look at the political dynamics of that state, and it's much more balanced. There's much more commonality in the political talk.
Simply because the politicians weren't beholden to the unions anymore, because the unions weren't able to pay the money like they used to?
Well, they sure do have a lot of money still. They're a $20 billion a year business, so they've got plenty of money. But their ability to compel people to pay them in those states that have right to work laws, and here in the 22 states that have compulsory fees for government employees, if we win this case, they won't be able to compel anything, and that will change the political dynamic. Because one of the things that union members object to and forced fee payers object to is the political stance the union takes, and they can vote with their pocketbook and say, "You're getting none of my money."
I see. Yep. So if they keep pushing an agenda that a lot of union workers object to, then they'll lose a lot of funding potentially. So they'll have to tailor what issues they take on.
Exactly.
I see.
They'll be more responsive. Yeah.
It's expected. I mean, the last time the court took a look at a case like this, it was 4-4, and now we have Neil Gorsuch. So I guess everyone believes he's going to be the decider.
Well, you don't make a living predicting what the Supreme Court's going to do, obviously.
Right.
But, the case you're speaking of, the 4-4 decision that was sent back to the Ninth Circuit out where you are, was the case called Friedrichs that came out of California on behalf of a California school teacher. That was argued in January of 2016. Obviously, Justice Scalia passed away in February of 2016. So the court sent it back to the Ninth Circuit 4-4 with no decision. The Janus case became the next case up. We anticipate we'll get a ruling probably at the end of the term in June, and we'll know one way or the other whether or not this court's going to protect the First Amendment rights of government employees.
All right, well, we'll have you back on either way, but obviously if your client, Mark Janus, wins, we'd love to talk to you again.
It's a big deal. It's a big deal.
All right,
Joe Biden would say it's a big deal.
All right, Mark Mix, thanks for talking to us.